Good day, everyone. Thank you for joining this webinar on the importance of contract awareness, risk management, and dispute avoidance with Paula Qatar, the legal manager at Kia International Consultants. Today, Paula will discuss the fundamentals of construction contract, identify key terms, and outline how to avoid common mistakes. She will also cover the importance of the contract review and negotiation stage to help prevent future disputes, outline the risk management strategies, and highlight how robust claim avoidance of disputes and safeguard respect and relationships. Our speaker will be Ms. Paula Qatar, and we will have our special guest, Engineer Ahmed Al-Ansari, the Technical Office Manager of Public Works Authority of Ashghal and CIArb President. And I will be your moderator for this session. My name is Mohammed Ilayam. I'm a senior engineer and a client rep for Qatar Fuel. And I'm also an arbitrator and expert, and I'm a board member in CIArb Qatar branch. We'll speak a little bit about CIArb Qatar, who is the host of this webinar. CIArb officially opened in Qatar in 2018. We currently have 14 board members, and we have 322 local members as of today. We have a partnership and agreement with Qatar International Court of and Dispute Resolution Center. Our agenda for today, we will first start with the speaker, Ms. Paula, giving her presentation. Then after that, we will give a good time for Q&A. All attendees are welcome to post at the Q&A box and present. We'll give it to the presenter to answer it at the end of this presentation. And finally, we will receive a closing remarks by our CIArb President, Engineer Ahmed Al-Ansari, at the end. We would like to introduce the speaker, Ms. Paula. Paula is a trilingual senior legal practitioner and construction claim consultant with over 21 years experience in the Middle East and North Africa and the GCC region. In this time, she has worked with international consultants and liaised with local and international legal counsels and various technical experts, and contributed to winning major claims and complex arbitration and litigation cases. She is a member of the Beirut Bar Association, and she is currently leading the legal and contracts and claims department at Kia International Consultants.
Hello, everyone. Thank you, Mohammed.
Ms. Paula, the session, and I will let Franco also start sharing his own screen. Paula, the stage is yours.
Thank you. So while Franco shares the slides, and there we go. Thanks, Franco. So this is the title of the webinar. It's the Contract Awareness, Risks Management, and Dispute Avoidance. If you can move to the next slide, please. Franco?
Yes, I have moved it. It should be showing now.
Mohammed, can you see the next slide? Are you seeing it in slide mode? So, okay, because I'm still only looking at the first slide. Can you confirm, Mohammed? Okay, there you go. So, a brief introduction about my company, Kia International Consultants. We are a well-known construction designer, management, and supervision consultant with a wide range of specialist construction consultancy-related expertise. The company has been established since 1965 in the GCC and the MENA region. It is ranked by ENR in the top 225 international design firms and the top 20 international PMCM firms, and by World Architecture as the 50th largest global architecture firm and #1 firm in the Middle East region in the 2021 WIS 100 survey. So we are a designer and a project management consultant for construction. And that's KO International, and I think you've heard about it. So if you move to the next slide, Franco. Just Franco, confirm, please, because I don't see that it's moving.
Yes, it is moving.
So this one is about me. You can move on to the next one, please. Thank you. So this is what was briefed by Muhammad. These are the points that we will be discussing. The next one, please. So contract fundaments. The purpose of this webinar overall is to establish my idea of that cure is, that prevention is better than cure. So the idea behind establishing contract fundaments, understanding the contract and having a good contract is actually to prevent risks and disputes on the long run. So the first thing is the contract fundaments. If you move to the next slide. So what are contracts? What are its fundaments? First of all, the agreement is an offer and acceptance, as you all know. And this offer and the acceptance must be reached before a contract can be established. It can be oral, it can be written or partially written. It can even be implied. This is the first and most important factor of a contract. Then you need the capacity and the competence of the signatories. And here comes the due diligence, when you collate the documents that actually confirm this capacity and competence at the outset of the agreement. You need the free will and the intention to agree. And most and foremost is the scope, the time, the price, and the payment terms. If one of these items is missing, you can't really have a proper contract. Next slide, please. So, for example, is a letter of intent, or what you know as LOI, or a letter of acceptance, what you know as LOA, are they contracts? Such letters are not a substitute to a contract. However, if we have no contract and we need something in place, we can have properly worded letter of intent. It's better than having nothing. Now, if you intend to have a binding letter of intent, then it should be signed by both POA holders. POA means the holders of a power of attorney to sign on behalf of their entities. It should include clear scope, time, and cost. And you would want to include a wording in line with this letter of intent is intended to create a legal binding contract between the parties. This way you make it more binding. Now, if you want that the letter is non-binding, you would simply say this non-binding letter of intent is simply a statement of the parties' present intentions with respect to its contents. Each party represents to the other that no reliance will be placed on this letter, that this letter does not and is not intended to constitute a binding obligation. But then you will need to have a contract in place as soon as possible. Next slide, please. The second point, so of course you will know that there are many aspects of a contract and many fundaments. I didn't go through all of them, I just went through the main ones. Now, if you want to draft a contract and you want to negotiate a contract, or you want to understand it, you will see that there are certain key terms that sometimes we see them, we run through them quickly, we don't notice them, or we don't give them the importance that they should be given. And there are also common mistakes that are to be avoided when we understand these key terms. Next slide, please. So I will try to take you through a few. There are so many key terms, we don't have time to go through them all, but I've selected a couple of them. Terms and conditions. Who doesn't know what terms and conditions are? So terms and conditions, they are the main and the essential topic in a contract. They are required for managing the contract. They set out the rights and responsibilities of each party. If they are breached, they allow the other party to terminate or to apply penalties or to require damages. It depends on each contract. So, but there are repercussions on a breach. The terms and conditions usually come in pair. There you can see general conditions and particular conditions. And the common mistake is sometimes technical people on a project, they tend to overlook the general conditions, because most of the times the contract just refers to, for example, general conditions terms as per a certain form, such as FIDIC form of contract. So they don't go and dig out that form. They simply read through the particular conditions and build their contract understanding upon those particulars alone. So be aware of this common mistake. Make sure you review all what is referred to as part of the conditions. You have examples here of terms and conditions that are important: the time for completion, the payment terms, such as time for payment, when does the payment gets paid, after how many days from invoicing, for example. You've got the scope of work and deliverables, that's the most important. We'll get to it also later on. Remedies in case of breach, insurances, guarantees, dispute resolution, law, and language. Next slide, please. So among the key terms, you will see that you always find this advance payment. Sometimes you see advance payment, sometimes you see mobilization payment. And there is a common confusion between those two. Advance payment is usually a payment that is not included in your total price or in the total price of the contract. It is a loan from the employer to start up the project, and it is recoverable through deduction of percentages from the interim payment certificates. So whenever you submit an invoice, the employer would deduct certain percentage, such as like 5 or 10% from each payment to recover this advance payment that has been paid at the beginning. Usually, advance payment bank guarantees, they often require, the advance payment often are conditioned to submitting an appropriate bank guarantee that would guarantee to the employer the recovery of this amount. What is mobilization payment and what's the confusion? Mobilization payment is usually part of the total price. It's not a loan, it's not an advance payment. It's one milestone of the payment schedule. It's not recoverable through deductions from the payment invoices, and it doesn't require a guarantee. This is the clarification between those two terminologies. Next slide, please. Back to back with main contract. Okay, this is not as simple as it looks. I'm going to use throughout the presentation the term supplier to refer to contractor, consultant, and subbies, because we're going to differentiate between supplier and client or employer. So what does back-to-back with main contract mean? It means that the supplier's obligations are expanded to the client's obligations under the client-employer or client-end-user main contract. So what do you do if you are a supplier? In this situation, you need to request a copy of the main contract. You need to review and understand the back-to-back obligations. And if you find a way to negotiate or to qualify, if it's not too late, if that main contract hasn't been signed yet, go ahead and try to negotiate. Identify and limit the back-to-back obligations to your scope, that you can do this one within your own contract. You can request your own client to qualify the obligations in the main agreement, to limit it to your scope. And of course, you need to flow it down to your subbies where it's applicable. If you have sub-consultants or subcontractors and you have a specific obligation in the main contract that should be flown down to these subbies, you should be aware of that and include it in their contract. And in all cases, you need to price for this risk. There is a risk of these back-to-back obligations. Sometimes they are too wide, sometimes you don't notice them all. So just price for them when you're tendering, and notify your insurance company, because we tend to have annual standard insurance policies and they don't review all the terms. They just see our revenues, our yearly revenues to cover us. So it's important to notify them whenever such additional or extended scope is envisaged. Next slide, please. Contract documents. This is also an important term, and it's sometimes, most of the time, it's referred to in the contract by combining several documents, like such as we would say the particular and general conditions, the letter of intent, the design scheme, the survey, the land survey, insurances, communication, warranties, you name it. And most of the time they include also the RFP, the proposals, the tender clarifications, all these things. And they say that these are all, they constitute the contract documents. So in this key term, we need to be careful for what we actually refer to as part of the contract. The final documents that make part of the contract should be up to date, and they should reflect the latest agreement between the parties. So whenever we have included several documents to avoid confusion and conflict, it's advisable to just include the final ones that have covered all the scope, all the program, all the payment, and those conditions and details. Of course, you need a clear order of priority within the conditions of contract. If you just simply collate the documents, you need to make sure that the priority sets out really the latest agreement first, and it's clearly mentioned in the contract. Next slide, please, Franco. Time is of the essence. You see that in contractor's contract and in consultant's contract. What does it imply? This reflects a clear understanding by both parties that delays will be painfully penalized and that payment of damages should be expected in case of delay. So when you see that time is of the essence, you should really be aware to submit a proper program and that your program is achievable. And the breach of this condition or the delay would give rise to remedies such as damages, termination, or even replacing the supplier and backcharging the related cost. Next slide, please. Thanks, Franco. Liquidated damages for delay and delay penalty. Key terms as well and common mistakes. What is liquidated damages? It's a pre-agreed amount to compensate the innocent party for the damages incurred in case of delay by the other party. So it is usually an amount that is reasonable, that reflects the possible damages which would be incurred by the innocent party because of the delay of the other party. Such provision is usually enforceable in court and in arbitration. Sometimes the judge or the arbitrator would adjust the amount to reflect what they feel are the damages and to avoid unfairness. And the delaying party could challenge this liquidated damages for delay in court by proving that no damages have actually been caused due to his delays. The delay penalty, on the other side, it's a pre-agreed amount, but it's intending to punish the breaching party for every day of delay rather than compensating for damages caused by the delay. So it is usually an excessive amount, and it usually has a maximum cap, say 10% of the contract fees. It applies to the delayed party without proof of damages caused, right? So just that it had delayed the project, these delay penalties can apply. For private clients, this can be challenged because private clients, for example, in Qatar and in many GCC countries, they fall under the civil law, and the civil law allows for challenging of this delay penalty. The judge likes to penalize, he doesn't like others to penalize others. However, if it's a public client that's under the public tenders law, such as a public entity or a governmental client, the public tenders laws entitle such clients to impose a delay penalty of up to 10% in most of the laws in the GCC. And it's just by simple event of delay caused by the penalized party. And it's really hard to challenge. And, you have to go through some public entities and refer the matter to them as a claim and so on. So it is always recommended that when a supplier is bidding or tendering for a state-funded project, he should be mindful of the client's legal right to impose this delay penalty and should price for it. Next slide, please. Fitness for purpose. You see it often and it goes unnoticed in many scope. It's usually in the paragraph of the scope of services. This is an obligation of achieving result. It extends to the fitness of the product to its intended purpose. It's usually under the contractor's contract. We rarely see it under consultant's contract. The fitness for purpose should be clear. It should be described on a performance basis and expressed in clear, objective, and measurable terms so that it can be practically applied. Suppliers would want to limit the fitness for purpose to the original scope because if there is a variation, some variation would not probably reflect a fitness for purpose. If you are instructed a variation, you probably would be able to perform the variation, but you could probably not confirm or commit to its fitness for purpose. So you need to be aware of this provision when you are instructed variations. It is usually not covered under consultant standard professional indemnity insurance. Okay, next slide, please. Scope of work. Scope of work is a main term, and having a clear scope of work really saves lives, I must say, saves you from hassle in the future. So try to identify it clearly, and that goes for both clients and suppliers. The clearer it is, the easier life is and managing the contract is. Define the areas and stages, list down the deliverables, indicate the deliverables format and duplicates how many design copies you will deliver, what format, CAD, PDF, all these sorts of details. List down the scope of exclusions. If you know of clear exclusions that could be related to your scope, list them down from now and avoid disputes in the future. Avoid catch-all clauses. What are catch-all clauses? We see it often. It says all works not mentioned, but which may be inferred, blah, 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 or including but not limited to, blah, blah, blah. I know that employers feel some kind of comfort adding these expressions, and they think that it covers all relevant parts of the scope, which they might have missed to mention in the scope. While this might be true somehow, it could backfire on them if a major part of the scope that was not identified because of this assumption they would say, okay, we don't have to identify all the parts of the scope because we've got this catch-all clause that, the contractor or the consultant will have to deal with this. They could be surprised eventually that such part or specific item of the scope wasn't covered in that catch-all clause, and it ends up becoming a variation. So have it clear. A clear, comprehensive scope is key to avoiding disputes, delineating variations, and ensuring that work is done and everyone is happy. Next slide. Intellectual property, you see that often. What is it? So many, I'm sure that so many people would read a whole page about intellectual property and not really understand what that means. And most of them have probably experienced some painful, some painful output of that. While it's not so well used in our region, in the US and in Europe, it's really a crucial item. So intellectual property is the ownership of the product, and that ownership is for the creator of the product, and it should be subject to a license to use. So usually suppliers tend to retain rights, but provide the client with a right to use for the purpose of the project, because eventually we need to move on, cannot just keep holding to the rights. The client needs to use these products and the drawings, for example. Clients insist, sometimes, most of the time, clients insist in their contracts to transfer the full ownership of the intellectual property right. The mitigation can be between these two parties by prescribing ownership transfer upon payment. So simply put a condition of payment if you are a supplier and request transfer of ownership if you are a client. And the obligations related to the intellectual property rights should be flown down to the subcontractors and the subconsultants, because you want to be able to flow down that ownership to your client, and your subconsultant or subcontractor has to have this obligation towards you as well. Next slide, please. Okay, so what does the term skill, care, and diligence mean? We usually see it mostly in our contracts as consultants, but it's also there in the contractor's contracts. It is the answer to the question, if other suppliers with ordinary experience and skill would have acted the same way in a certain circumstance. This is the general practice. Failure to follow this general practice may be evidence of negligence. Of course, if this goes to dispute, that will be a subjective assessment by the experts and the judges. But just understand that it's usually the general practice in a certain area. Next slide, please. Suspension and termination. So these rights are enacted by either party. They may have very serious consequences if not undertaken correctly. Incorrect or non-contractual suspension or termination by a party may amount or may become or may be considered as an act of repudiation of the contract. That means that if the services are suspended without giving adequate notice to the other party, mainly the client, or not in accordance with the contract or as the contract allows, the client may be entitled to terminate the contract by insisting that the supplier or contractor or consultant is unable or unwilling to perform the works or the services. And then it becomes the client's right for damages, for termination. And in any case, if the suspension or the termination are provided for in the contract, they should have a limitation, they should be really detailed, and suspension itself in particular should be limited in time, should not be an open suspension forever, because it's it includes an open risk for both parties, and particularly the supplier who's keeping his overhead and labors, for example, on hold indefinitely. So make sure that the contract limits the suspension to a certain deadline, beyond which you can request or you can be entitled to terminate the contract. And for sure, as always, include similar right of suspension or termination in your subcontracts. Next slide. Force majeure or unforeseen events. We've seen this a lot these couple of years from COVID, and the regulations related to it. So basically, the definition is it's an event beyond the control of the parties. It makes it impossible or illegal for a party to perform. It should be defined in the contract. That's the recommendation. We rarely see a definition in the contract, and we rarely even see a note, a provision in the contract about it. You can see examples of force majeure such as act of God, war, rebellion, riot, or disorder. In this event, the party shall not be considered in default or breach because the force majeure has made it impossible to perform. And the contract may include the right to terminate if the force majeure continues for a certain period of time. A well-crafted contract would have itemized the specific and clear force majeure events with exclusions. I have come across recent contracts where COVID-19 or pandemic are expressly excluded from being force majeure or unforeseen event. And this is recently, and this is justified in my opinion. So also make sure to prescribe the full implication of such force majeure to both parties. In case of no or insufficient force majeure clause in the contract, you can simply refer to the law. Some provisions, some law, certain legislation have allowed for force majeure without really defining it. You can see something like unforeseen event, impossibility to perform. Some legislation apply, some wordings just like by facts, and eventually the judge will subjectively define if or what is a force majeure or is an unforeseen event. Mitigation for the supplier is to promptly notify the supplier or the client. Each party who is facing the force majeure should notify the other party, should endeavor to perform the obligations, and the services completed prior to the force majeure event should be paid. Next slide, please. Tip of the day. I like to give a tip of the day for this terms and contract awareness. It's to review and understand all the terms and conditions, especially the tiniest ones. And this is actually a personal advice, because if you go to a bank or your insurance policy, you dig into it, you will see really tiny conditions that you may not even notice are there. And sometimes they are really, important, and they can really impact your rights. Next slide. So point 3, importance of contract review and negotiations. Next slide. So why is the contract review important, and why is negotiation important? It's for avoidance of future disputes and unnecessary regrets. So the ultimate goal of a contract is what? For the client, it is to acquire the service, the design or the construction, the building, and for the supplier, it is to do business, to earn money. So when each of the parties understand at the onset and accept and respect the other party's goal, the negotiation will be smooth, and the contract drafting and implementing will be fair, and there will be a happy ending for all. So we have to keep the goal in mind. That's why you need to set your minimum contract terms. When you go to negotiations, or when you start a negotiation procedure and you need to review a contract, you need to have your minimum contract terms in mind. These are your view on your vision on your business, how you want the payment terms. You have to put, what I can accept, why I don't accept, what is a deal breaker for me, what I should price for the risk in terms of payment, in terms of suspension, termination. I'm giving you just examples, you know. You can have your own minimum terms. It can be intellectual property rights, it can be anything. So you need to keep that list in mind and circulate it among your bidding teams. I have chosen event of delayed payment. What do you do when there is a delayed payment? Do you ask for suspension, termination? Do you incur, I don't know, compensation fees? How about retention? Do you want a retention or is it a no-go? Liability, should it be limited in time and in amount? Warranties, do you provide a collateral warranty or it's a no-go? Do you provide parent company warranty or no? Guarantees and bonds, how you want your performance bond to be. Do you want it to be limited in time, fixed amount? All these details have to be understood. Next slide, please. Insurances as well. You know, there are some recommendations for insurance. For sure, you want to have an insurance because it covers you before the other party. You want to limit the aggregates. What aggregates? You want an extended reporting period, cover to others, you know, all these insurance details, they are really important to be understood. Variations, management procedure, how you want the variations to be managed, instructed, timeline for agreeing impacts. When do you submit the impact proposal? Do you require approval before implementation? The client requires implementation before approval. All these details, you need to have them in mind when you go to negotiation. And, you know, the recommendation, of course, is to engage skilled technical and contractual reviewers within your bidding team. Next slide, please. Fourth point, variations, risks management. Next slide, please. Okay, so we've spoken about the contract fundaments, how you understand the contract key terms, how to avoid you know, common mistakes, but and how to mitigate risks in general. But the basic and the most important risk in construction, and you will agree with me, are variations. Variations add cost, they add delays, and they add scope, and you name it. So what are the instigators of variations? How you should manage your variations? First of all, you need to track the instigator. That can be meetings minutes, that can be correspondence, emails, client preferences, changes to the project brief or design, resequencing of the work program, or splitting up tender packages, splitting up the project into, you know, sub-projects, for example. That's a variation. Inadequate workmanship or design, that causes variation as well. Inadequate tender or contract documents, that will eventually change to, you know, to accommodate certain requirements. Keep your eye on it. Inadequate construction information, such as, for example, survey report or, you know, concept design or something like that. Or probably an error in installation. Contractor or design delays. Contractor submittals for alternative materials or products, that could also entail variation. Delays by local authorities, municipalities, changes in statutory regulations. Now, you will see, these are just examples. You will see in some contracts, these could be excluded. Some contracts would say that local authorities delays are, you know, are not, do not constitute delays. They are to be, you know, like borne by one of the parties. The statutory regulations as well. Some laws changes may not be delays, considered as delays, depending on the contract. Next slide, please. Or variations, sorry. So how do you mitigate the variations risks? That's the main point in this variation part. So you have several stages. You have the first stage at contract drafting and negotiation stage. So what do you include in your contract? Start by including a detailed schedule, timeline, and a clear specific scope. include variation mechanism, timelines for submissions, approvals, and implementation of a varied work. The basis of pricing, how is your rate built up? How is it used in your fees so that you can use the same principle in variations and you can avoid dispute on how you build up your rate when you claim for a variation. Put deadlines for agreeing entitlement on impact and encourage agreement before it's too late. When is it too late for agreement? When the variation becomes a claim, and a claim becomes a dispute, and a dispute becomes litigation. So we want to avoid that. So some suppliers include in their contract a right to suspend or terminate an implementation of a variation in case no agreement on the impact is reached within a certain deadline, the cost and the time impact. Some suppliers request a no start of implementation unless the impacts are agreed. And of course, a written clear variation instruction is received by the authorized person. Next slide, please. So that was at the contract drafting stage. Now the contract is there. And what do? We simply manage it properly. When variation occurs, how do we manage it? We have to identify and record the change. We need to notify as per the contract. There is usually a notice deadline in the contract we need to respect, and document the change as you go along with the project. And then you have to integrate the change into the project scope within like a sort of a common agreement, like a variation order signed by both parties. Next slide. So in general, as a recap, throughout the project, if you are a client, try to avoid variations. If you don't want to avoid the variations, it's important to understand its impact because the clients will eventually incur the impact. I have a clear instruction because you want your variation to be implemented clearly and as you really want. If you're a supplier, notify the client of the variation whenever you feel there is a variation. Try not to implement any change unless it is duly instructed or approved by the authorized person. That's called, practical. That's actually not the practical way of doing it, but that's the contractual way of doing it. I know that practically we are all in a hurry. The client asks us to do something. We want to be nice. We do it. Yeah, I mean, it's okay to do it, but you need to be sure of your client. You need to really have a good relationship and you need to record it immediately. You record it via letter, via a request for instruction, a confirmation that you have actually started implementing an instruction and that you demand a formal instruction by the authorized person. Comply with the notice requirement, as I said initially. Preserve entitlement to claim for time extension and additional cost, that you should mention that in your claim. Request clear variation scope if there is unclarity. Preserve the right to reject the variations that are really beyond your capacities and your scope. You need to be able to refuse to implement something that could put you at risk of errors or omissions. Submit proper claim, details of the changes, the rates, how you built up your rates, the quantities leading to pricing, any quotation from the market or probably anything from your contract. Adjusted time as well, submit a delay analysis, show how this event of variation has impacted your time, if it has, and so on. And most of all, maintain submittals records. Approved timesheets, invoices, meeting minutes, letters, reports, anything that is related to this variation and that can prove it eventually when you submit your claim. Next slide, please. So the last point now in our webinar, how a robust claim avoids disputes and safeguards respect and relationships between the parties. Next slide, please. Okay, so I cherish this part. Claims are really dear to me because I come from a claims background. Of course, I tend to avoid and I want to avoid claims, but when there is no way of avoiding them, if all the aforementioned good contract awareness and risk management did not really succeed in avoiding a claim, get into it with elegance and grace. What does that mean? How do we submit an elegant and graceful claim? That means it's a clear, fair, well-written, well-supported, and well-presented claim document. It should aim to maintain relationships and respect with the other party, be it a client or a subcontractor or any other, but you know whom you're submitting the claim to. You are chasing, you're right. You're not chasing anything beyond that. How do you prepare for that? How do you achieve all that? It's by claim anticipation. I know that you don't want to start your project with claims in the background. That's why you have technical people doing the work and you have contractual people in the background supporting any potential claim or other. So there's nothing wrong in anticipating and preparing. This is totally professional. File, document throughout the project. Put your files, your sub-files for each suspected claim. Instruction, communication, minutes of meeting, submittals, review, comments, approvals, chronology of relevant facts, rates, quotations, receipts, paid checks, etc. Anything that you can use in the future. That's why you need specialists to do that. We tend to leave this to the last minute, and you know, people are running all over the place trying to dig out documents. Most of the site or most of the project people are no longer, present, because usually claims are, especially in this part of the world, they are left till the end of the project. And by that time, the records would be lost, people would be lost, memory would be lost, and then it's really, really difficult to prove your claim. Compliance with contract procedure. There will be for sure a claim procedure in your contract, at least hopefully there is. Put a summary for it, have it ready. I used to, in my previous company, I used to produce procedures. You just take it out of the contract, you put a diagram, you put a table, action by, deadlines, you make it clear for project people to really know what will happen if something like that is, is needed. And seek experts' advice and support. If you have a really big claim and it's a little bit delicate or complex, I recommend to seek experts' advice and support, specifically forensic people, probably to give you, the basic or the ideas or just direction on how you have to build your claim. It's all for the interest of having, as I say, an elegant and graceful claim. Next slide, please. So let's say you have done all that due diligence, you've been preparing your file. Now you are there, you need to prepare your claim. What do? You need to analyze your facts, events, numbers, dates, have them all clear in your mind and on papers. Present the facts in a clear narrative. The narrative is really important. It has to be concise, clear, and to the point. Present contractual and legal backup from your contract. Prove why this is considered, why this claim or this event is a claim. Find in your contract backup for it. Enclose the documents confirming the facts. Reproduce the facts and the quantum or the numbers by inserting charts, diagrams, and summary tables to your claim. That will make it clear for everyone. Hold meetings with the other stakeholders, with your clients, after you submit or before you submit. Communicate. Hold a presentation and circulate clear to the point summary booklets. I will give you, for example, I can share with you a very recent success story that I had with a recent claim by KO. which we prepared in-house, and we seek probably some input from experts. And we have succeeded in winning one of our biggest claims in Qatar with a major public client in Qatar who is well respected. And we maintained relationship and respect. It took some time because, it wasn't handled properly at the beginning. Then when we put all the efforts together, we maintained we built a teamwork within the company, technical, contractual, and everyone on board. We extracted all the relevant facts. We put them in a clear format. I will tell you, I will give you examples of what clarity is. For example, simple things, really simple things, numbering the paragraphs, putting clear sub-paragraphs, page numbering, refer to the relevant appendix. Whenever you mention it in the narrative, refer to it, name it. Add footnotes. The footnotes would clarify an idea, or probably would refer you back to a previous paragraph or to a future paragraph. Put contract clauses, quote them, quote articles, include separation sheets between each head of claim or subject. If you have several folders, hard copies, tag them, title them, number them, use the technology, print neat and clear tag files. Presentation is key. Have a clear claim, because if you or your organization can read and understand it, so that your client. And that's what we did. We communicated, we were clear, we were prepared. If you go to a meeting, be prepared, memorize your claim, memorize your arguments. You don't just simply go and read your claim. You have to go beyond your claim, convince, put your arguments on the table, show that you are right. And good luck. And I think that's it. Q&As, anyone? Thank you, Muhammad, you're on mute.
Thank you, Paula, for this interesting session, and very fruitful and informative, to be honest. I'll just reshare my screen. Yes, we will start now with the Q&A session. I hope whoever have a question, just add it to the Q&A. First question we have is from Vineet Sankar. I hope I spelled his name correctly. He says, many presidents are seen where the courts take a different view on back-to-back contracts. They tend to nullify the concept, especially when it comes to payment. What does it generally mean in the civil law countries, and what the law says about that?
Yeah, well, you will see in the contracts in this region a lot of terms that are mostly taken from the common law, because we've got a lot of British and foreigners dealing with contracts here. But yeah, he's right. If you go in the civil law, if you go to court and you really challenge a certain back-to-back condition that is irrelevant to your scope, or a back-to-back payment when you have really done your work, that could be considered. It depends on how the contract is worded, and it depends on how fairness, like the judge would eventually decide upon fairness. It could be challenged somehow, yeah.
Eric has a question. He's saying, what kind of power have the minutes of meeting? Is it enforceable? So he's asking about the enforceability of minutes of meetings during the meetings and sessions and so on.
Yeah, so first of all, if nothing in the contract describes the communication, because usually contracts have a provision about what communication, how communication is undertaken. Is it emails, is it fax, facsimile, like the details of communication. Usually, and normally they don't mention minutes of meeting as part of the communication or instructions. However, in civil law, if you go to court, any document can be part of the evidence. It doesn't have to be the only evidence, but it adds to the facts that you are referring to. And if a minutes of meeting is signed by all the stakeholders, all the attendees, then yes, it's a binding contract. It's like a contract. It's a binding statement, I must say. There are many ways how you can make a minutes of meeting binding. You can circulate it to the stakeholders, to the attendees. You can confirm its content, and unless nobody objects, then it's confirmed. There are many ways. You just can record it somehow. That's how you can make it more and more binding.
And Mohammed Ansar is asking how we can avoid onerous contracts from the main contractor. And I think I have the same issue that mainly, main contractors comes with a bundle of documents and say, this is your contract, whether take it or leave it. So how the subcontractor, who's generally much smaller in size and doesn't have the contractual experience while dealing with main contractors or international contractors, save themselves from, huge contracts with comes hundreds of pages?
Leave it. No, now seriously, you need to know your risks. You need to price for your risks. Of course, some provisions can be against the law. Those will be unenforceable. So if you want to enter into such contract, I advise you to be informed. Seek consultation by a lawyer. If any stringent or any unwanted provision is really against the law, you will know that it will not be applied, then you can ignore it. But that means that you are eventually going to court. If you see that this contract will eventually lead you into disputes, simply price for the risk or leave it.
Also, Mohammed is asking, is it very important to keep arbitration clause in the contract as it looks more expensive and time consuming?
Yeah, there was a time when arbitration became a trend and every small or big contract would refer to arbitration. Of course, some arbitration centers are cheaper than others. Some arbitration clauses make it cheaper than others if it refers to one arbitrator or to a panel of arbitrators, or if it refers to an international organization. Also, the seat of the arbitration, is it international, is it local? All these details should be taken into consideration when you decide to choose local court or arbitration. Usually, if it's a minor contract with a small contract price, arbitration would be too onerous and you eventually forfeit your right to dispute because it doesn't make sense to pay that much to get this much, And usually in international contracts, parties tend to put arbitration because no international party want to be under a local court or a local law, or so many things are to be taken into consideration, but there is no obligation to put an arbitration, a dispute arbitration clause in your contract. You can simply refer the disputes to courts.
I'm just going to add to Mohammed's answer on his question. In order to go to arbitration, you need to have an arbitration clause in your contract. Without it, simply you cannot go to arbitration unless both parties agreed again separately to go into arbitration. But can you remove it from contracts? Yes, you can remove it and keep it as a litigation process to courts and move with the dispute.
Of course.
The next, yeah.
That's
if you want to comment on that, yeah.
I just want to add one point here, that not just because you have an arbitration clause in your contract that you should go to arbitration. Sometimes arbitration clauses are incorrect and inapplicable, so that you end up having to go to court eventually if your clause is insufficient or incorrect. But of course, this is left for the parties' agreement, whether they want to go to arbitration or agree on a different dispute resort.
Totally agree with you. And unfortunately, many cases we see here in Qatar, especially, that the arbitration clause itself is crippled because the one who drafted didn't put enough, you can say, data, or he didn't explicitly say how arbitration process will go. So even that arbitration clause is there, the court will rule to go to litigation and remove the arbitration from the contract. We have Mr. Sridhar asking, what are the difference between liquidated and ascertained damages and liquidated damages?
Liquidated damages is something that you agree upon ahead of time, and it's an estimation of what the damages will be. Certain damages tend to be the damages that have actually occurred, and that will be quantified eventually by the judge.
We have also Mr. James. He's asking a good question, actually. Do you recommend using lawyers or contract specialists at the negotiation stage, or only later when things start go wrong? So when we put experts or contract experts, lawyers, counsels into force or being beside the contractor? Okay,
so let's be practical. I am a lawyer and a contract specialist, and I intervene with my company's negotiation of contracts from the outset. And I have my team also, so we all review the contract at the beginning from tendering stage. That's recommended, of course. But practically speaking, if you have a small contract and you don't want to incur legal fees at the beginning, and if you see that you have a contract person who is competent enough in your organization to raise these main points, which you can refer to my webinar and see the main terms that you need to be aware of. So you just need to have common sense. It's not really legal. It's mainly common contractual sense. Know your risks. But if you can afford a lawyer for a big contract where there are major, where there is major risk at stake, then please go ahead and do it.
Wouldn't you agree that if the contract is lengthy in terms of having too many details in it, even if you are doing a small job, regardless of the fee that you're going to pay for the specialist or the lawyer to review that terms and give the contractor a summary of all the risks and all the exposure they have on the contract, would save them eventually a lot of costs, because once they go on board and they start spending money doing the job, and dispute happens in between, and they found that it's one-sided contract, and they have no rights or they have no details that can save them from the force of the main contractor on them.
We all, we're fighting against all the mean main contractors out there. Sometimes the main contractors are really poor people,
True. I'm speaking about the small fish against the big fish sometimes.
I know. It's like that usually. Or sometimes clients even, we have some clients' contracts that are unqualified. You cannot even qualify them. You cannot even comment on them. And you have to sign an acknowledgement that you are not qualifying any term. So this happens. It's a risk, and that's business. When we do business, we take on risks. And to go back to your question, practically speaking, if it's a small contract, even small contracts for small contractors or small subcontractors can impact their business. And I cannot say that it's just a small contract. I don't have to, I don't want to pay a lawyer, but eventually, if it's a risky contract and it really impacts your business, it can really destroy this small contractor, for example, or subcontractor. So they need to know, they need to evaluate their risks and what this contract represents to their business and how much they want to invest on having a properly worded contract from the beginning. And of course, negotiation skills are key. Have a negotiator within your team, and if the client is open to negotiations, of course. Otherwise, don't waste your time.
I agree on the point. Muhammad Ansar is asking again, is it good to keep like programs and meeting minutes in the contract documents? Maybe more chances for coordination and if delay happens?
Of course. Look, I recommend putting anything that has contractual implication or provisions. It can be a letter, it can be, sometimes we have so many revisions of letter of intent, for example, or we have revisions of proposals. If any of those revisions or any of these minutes of meetings or letters have contractual implication or provisions in them, yes, of course, we need to include them if we haven't covered for these provisions in a different contract document. But if we include them, we need to be aware of their priority. Because for sure, if you have so many documents, you will find conflicts here or there. You need to make sure that the priority lists really like your scope. Sometimes they put general conditions as priority. I would always recommend to put the scope of services as a priority, the schedule of payments as priority. All the conditions and terms can come later, for example. So yeah, just know your priorities and put the documents accordingly and mention it clearly in the contract.
Vineet Sankar is asking, based on the latest discussion on client enforcing a clause on a contract and with the policy take it or leave it, contract prefertum saves the innocent.
Yeah, well, of course, if you have to sign a contract with clearly onerous or, as I said, illegal provisions, you can challenge that at court. But do you really want to go that far? If you're entering into a contract that will eventually take you to court, do you really want to enter into that contract? That's the question that you need to ask yourself.
Mr. Ali Ayyad is asking, what about joint venture agreements? How to avoid disputes between the parties? What do you recommend in drafting GV agreements in terms and conditions?
Like any other agreement, just have clear conditions, separate the obligations of each party. Who is the leader of the JV? Who deals with the client? Who signs the contract with the clients? Who communicates with the clients? Is there a committee who decides for the JV? You need to put all these details in the JV so that you avoid conflicts and disputes. The clearer the JV agreement is, the better it is to manage it. So the basics for a JV agreement, of course, are the purpose. Why are you entering into the JV agreement? What project are you bidding for? Who is the client? Who are the stakeholders? Are there any possible subbies coming later? Are you a subby? What's your scope? What is your main scope? Are you just entering as a JV partner, or are you becoming a sub-consultant or a subcontractor eventually? Who's going to sign the ultimate contract? As I said, who leads the JV, who communicates, who gets the payments, who signs the invoices, where does the payment go, which bank account? Is there a joint JV account? Is it your account? Who submits performance bonds? Is it a joint performance bond, or is the leader submitting his performance bond? You're just submitting a sub-performance bond for the leader to cover the leader's bond. Who's submitting insurances? You know, all these details. There are lots of things to think about with a JV agreement. Some JV agreements require incorporation in some part of the GC world.
Lengthy process, yeah. I need a lot of details to look at.
Like any other contract, but like different flavors.
Last question, please, Mohammed. Mohammed, last question, please. We need to close the session.
Last question from Kathleen. If a portion section of work is suspended and then the client decided not to proceed with the portion or section of the work, is this considered a variation? How suspension portion of work paid and reflected in the final account?
If it's a suspension, then that's different. That's that should be considered within the suspension conditions in the contract. Suspension can be open-ended or can be limited in time and can lead eventually to termination, depending on the contract. If it results into omission, then it's a variation. Variation is addition or omission. If suspension leads to omission, then it has to be recorded as a variation.
We will conclude on the Q&As. If you have any further Q&A for Ms. Paula, you can simply send her an email. Her email is in the screen, paula.qatar@qoic.com. We would like now to have Engineer Ahmed for the closing remarks. Mr. Ahmed is our CIArb Qatar branch president. Mr. Ahmed.
Shukran, Mohammed. Thank you very much. Thank you very much, Paula, for a very insightful presentation. It was great. You just took us through from the outset of getting into a contract all the way to probably the end. We didn't get much into the dispute resolution, the alternative dispute resolutions. Anyway, for any contractor, when it comes to pricing any job, they always would look at risks associated with such contract. For instance, what we've done at Public Works, we identified the risk profiles associated with the different type of contracts when we worked out the new suite of contract. And thereafter, we decided on the risk allocations in relation to the traditional contract, for instance, the design and build and the like. And one thing, we have considered in working out the terms and conditions of those contracts, risk sharing. Maybe in the past there were very little risk sharings between contractors and clients, but now you may have noticed from our 2018 version, there are many risks are shared between us as client and contractors. But nonetheless, we know that contractors are very much risk aware, and they normally, it's all worked out and built and charged at premium. So one important thing is the client attitude and the client way of managing its own contract. Paula, I think, was very polite in referring to an example of a claim that she submitted to one of Kiyo's clients. But I remind you, there was a claim which you submitted to a public entity here. It took more than 5 years to resolve, and at the end of that claim, there had to be a kind of intervention to resolve it and settle it in a short time. So it's very important for all of us to very well understand the terms, conditions of contract, as Paula said, the scope of work, and whatever associated with delivering any construction job here in Qatar. Many people think public contracts are very client biased, and there is very little to maneuver for contractors. For that purpose, they consider risk too high, so they overcharge for the jobs they deliver. Anyway, thanks, Paula, for this precious presentation. And I would like to invite all our members to prepare for next year. Next year is going to be very busy for us. We are currently working out in developing a calendar, which would include many events, training programs, and not to mention the annual member assembly, which we are hoping to organize just a few days before Ramadan. And I must emphasize on the attendance of the annual meeting, because last year I was a little bit, to be honest, disappointed, though many people confirmed attendance, but unfortunately only 65 to 70% showed up. I must say that we paid for the full number of people registered. So this is why I would like to see those registering for the upcoming annual meeting to attend as well, please, because it is not just a meeting and discussion, but that would be also followed by the annual dinner. Thank you very much, Paula, and I look forward to seeing you very soon, hopefully in our January events and next year events generally. Thanks to all the attendees this evening, and I wish you a very pleasant night. And I'm sure you're all going to watch the match tonight between Algeria and Qatar. And I believe Tunisia and Egypt is ongoing right now. I haven't watched it, to be honest. I don't know what's the score so far, but I wish everybody good luck. Thank you very much and good night. It's back to you, Mohammed.
Thank you, Paula. Thanks, everybody.
Thank you all. Thank you, Mr. Ahmed. Thanks for hosting me.
Shukran, Paula.
Bye.